like you're ready. Mr. Squires, you may begin.
Thank you. Good morning, Your Honors. May it please the Court, my feelings are a little hurt that we lost our audience. I am, like Justice Mansfield, an import of the state of Iowa and went to high school in Chicago suburbs. Your Honor, representing the defendant and the appellant in this case, Thomas L. Cardella and Associates, I don't think it's an understatement to say that this case has significant economic and public policy implications for employers in the state of Iowa. The district court below allowed the plaintiff, Jenna McCoy, to pursue a tort theory against her employer through trial and a jury verdict in a way that contradicts Supreme Court precedent and contradicts the legislative remedies, the statutory remedies for workplace claims. If the verdict and if the theory that upholds that verdict or underlies that verdict is sustained on appeal, it creates really unlimited exposure for employers in the tort world for employee claims of torts that are preempted by workers' compensation law. The particular tort that the district court permitted to go to the jury and reach a verdict was a claim of negligent supervision, negligent training, negligent retention. Ms. McCoy claimed that Cardella and Associates negligently supervised two of its employees who she claims then committed assault and/or an assault and battery in the workplace. This court in Estate of Harris versus Papa John's Pizza categorically rejected the existence of that tort, and that's a 2004 case. In particular, the Harris court held that a corporation's failure to prevent an assault and battery on a plaintiff employee cannot sustain a negligence claim against the employer because the claim falls under workers' compensation law.
I believe that your opposing counsel's position on that is that the damages that they're seeking are more the damages related to your client's response or lack of response in her position rather than damages from the assault and battery themselves. What's your response to that?
Your Honor, I don't think that's how the evidence played out at trial at all. As the court knows, we had highly contested testimony from the plaintiff's healthcare provider who initially had testified in her deposition that all of the harm flowed from sexual harassment. Then at trial, she changed the testimony after the court had excluded her deposition testimony and said, no, all of the damages, and again, it's only emotional damage in this case, all of it flows from the, quote, assault and battery and the unwanted touching, the comments, et cetera, et cetera. I don't believe there's any evidence that Ms. McCoy said it was the absence of a response from the employer, nor do I think it makes a difference because it's still the same tort theory that the Supreme Court has excluded.
Ms. McCoy had made a work comp claim for mental injury under the Dunleavy theory.
Oh, yes, Your Honor. The way we view this case is McCoy had two different possibilities for recovery. She could have and should have followed the Iowa Civil Rights Act because her claims really sounded in sexual harassment. In the alternative, since she recast them as employment torts, she could have, under Dunleavy, pursued a workers' comp claim. Dunleavy clearly stands for the proposition that mental injuries are recoverable in workers' comp. There does not need to be an associated physical injury.
I have a question on that. As I read our Nelson case, it seems to say that the mental injury has to be in some way disabling, and that's what sort of puts it under workers' comp, and that if the mental injury doesn't disable the person, then perhaps it's not covered. Am I reading that wrong?
I don't know, Your Honor. I'm not familiar with that particular language in Nelson.
Here is what it says. But if the essence, and this is from Nelson, but if the essence of the action is recovery for physical injury or death, including in physical the kinds of mental or nervous injury that cause disability, the action should be barred, even if it can be cast in the form of a normally non-physical tort. And that's a quote from the Larson Treatise that we've cited a bunch of times.
I would query what is the meaning of disability in that context, because the word disability is often used in the workers' comp context, I think, as synonymous with injury. And did I suffer an injury? Did I suffer a disability? And it might be a very hard line to define. Where does one end and where does one begin? You know, in the Dunleavy case, I think the injuries were all mental. They were derived from stress. And here, that was precisely what Ms. McCoy was claiming at trial, that she had depression, anxiety, so on and so forth, all of which was exacerbated by the conduct she claimed occurred in the workplace. But in terms of, you know, the fundamental issue here, Your Honor, and that is the legislature has prescribed workers' comp as a very broad section of remedies for employees who are injured in the workplace, whether it's physical or mental. The reason for that is to partly, at least, to protect employers from tort liability, such as the tort liability that exists in this case, where you have a jury that really has unlimited purse strings that they can spend on, and that's from a public policy perspective and a legislative perspective, that's bad for Iowa employers.
Work comp as opposed to the ICRA preemption, or that?
It depends where we are in the case, Your Honor. When we first read the petition, and the very first paragraph of the petition uses the word sexually harassed 3 times, we filed a motion to dismiss under the Iowa Civil Rights Act because it would be preempted by the Iowa Civil Rights Act. The plaintiff, recognizing that, abandoned the ICRA claim and said, no, this is a workplace tort, and that's how it was really, quote, litigated and went to the jury. The reason it shouldn't have gone to the jury is that that was the theory, if you will, that was going to allow recovery under the district court's approach to the case. But that theory is preempted by workers' comp law under Harris, under Nelson, under Otterberg. So that's primarily why I'm focusing on that on appeal.
It's because you didn't address the Greenland case in your briefing. And that's one that allows assault separate from a civil right, or recognizes that assault could be separate from a civil rights case.
Yes, Your Honor. In Greenland, first of all, that was a 1993 case, I believe. So it predates Harris and the other cases that we relied upon. The procedural posture also was a motion to dismiss. Excuse me, I'm getting very dry. And I don't think workers' comp was even raised in that issue. So, and so the court in that case could say, well, I'm not going to disallow you to pursue an assault and battery claim because that may exist, but the employer never challenged that under the workers' comp side of the coin.
Reconcile Greenland with the later case of Smith that speaks broadly of preemption by the Iowa Civil Rights Act if you know it's the same conduct involved.
The procedural posture, where in Greenland we're at a motion to dismiss, and we all know how difficult those are to succeed on. In fact, this court has told district courts don't grant those for the most part. At the pleading stage, you could make the argument, I think. But when it comes to the proof and the pudding, Smith is very broad in terms of what it requires to be pursued under the Civil Rights Act. You know, in particular, if the conduct that's complained of would support a claim under the Civil Rights Act, that is your sole and exclusive remedy. And here,
It's good law after Smith. I mean, Smith doesn't cite it, doesn't expressly overrule it, but they seem very inconsistent to me, and maybe we should overrule Greenland.
problem with that, Your Honor.
Brings up that Greenland involved a straight assault and battery as opposed to negligent supervision related to a co-employee's assault or battery. But that kind of gets into the issue of negligent supervision when it's an employee against an employee. Have we ever expressly recognized negligent supervision in that context? I know the federal district court has said that we would or that we might have. What are your thoughts on that position?
If there is a case where the Supreme Court or Court of Appeals has permitted this type of claim to stand, I haven't found it. I don't think there is a Court of Appeals case or a Supreme Court case that says there is a claim of negligent supervision, negligent hire, negligent training, negligent retention that an employee may bring against their employer. There is a separate theory where a stranger to the workplace can bring that type of tort. No question about that, but that's not the fact pattern we have here. And it's a different situation because of what they call the grand bargaining under the workers' comp framework that says employers should not be exposed to this type of potential liability.
What are we to make of the denial of the workers' comp claim here?
There was no denial, Your Honor. She never pursued a workers' comp claim. The problem for Ms. McCoy in this case is the problem that many plaintiffs have in litigation. They missed the statute of limitations. So she could have pursued a civil rights charge, but she missed the filing point. She could have pursued a workers' comp charge, but she never submitted it. And so then I think on the close to the eve of the statute of limitations, we get a tort claim.
Is that in the record? As far as if they missed deadlines, is that acknowledged? That deadlines were missed for the Civil Rights Act as well as workers' comp?
For that in the record, Your Honor, is there clearly was never alleged an exhaustion of administrative remedies that's required. It's not in the petition. I don't think it's a contested point. In terms of workers' comp, we did ask her at trial, you're aware in the employee handbook that there is a workers' comp section where if you have a workplace injury, you're supposed to go to your employer. Did you do that? Her answer was no. And so, yes, it is in the record that she did not pursue a workers' comp remedy.
Give her concession in her appellate brief at page 37 that she could have brought a claim under the Iowa Civil Rights Act. Is that fatal, or is that fatal to her case based on preemption of that statute?
And at face value, Your Honor, that is a dispositive concession, because if the facts underlying her claims would support a claim under the Iowa Civil Rights Act, she has to take that path. And again, I think if we go back and look at the petition she filed, that's where she started in this case as a sexual harassment claim, recognizing she had to call it something else, but it's also the case that was litigated. And obviously, we've identified other errors we think occurred at trial with repeated references to sexual commentary, to sexual conduct, to sexual touching. She was trying to disguise a sexual harassment case as something else. That in itself is a problem, but then when it leads to a secondary problem of creating a new tort against Iowa employers, it's Katie bar the door for liability going forward. I have about a minute and a half left. I do want to touch on the inconsistent verdict a little bit because I think that's significant. The way the court instructed the jury is in order to find Cardella negligent for supervision, the jury had to find that there was misconduct, assault or battery by Turner and Thompson. The first jury question said that there was no assault by Turner, but then question number 5 said negligent, or said Cardella nonetheless was negligent for retaining or supervising Turner. We submit that that verdict cannot be reconciled because there can't be liability for Cardella if there's not an underlying tort by Turner.
Court kind of reconciled those by saying that the instructions all said and or related to Thompson and Turner. I looked and I think both parties submitted similar verdict forms and everything seemed to have the and or. Is that something that is one of those errors based on the jury instructions, or do you think that even with the and or is it still your contention that as read that the jury still had to find Turner had committed an assault before it could find negligent supervision related to him?
Absolutely, that's the way that the sort of interrogatories were phrased, by going Turner, Thompson, Turner, Thompson. And you just can't find that Turner didn't commit the assault and then find that we're negligent for improperly supervising him. I would like one more comment. I'm out of time on that topic.
Quickly, because you get to come back again anyway.
Very quick. The problem with McCoy's response on that is she says in her brief, it doesn't have to be an assault. It can be something else. If it's just bad conduct, there can still be negligent supervision. And I think that's another place where we have Katie bar the door, because where does it end if an employee is dissatisfied with how their supervisor treats them? They can say, I didn't like my job review. I had a wrongful discharge. I was bullied, and it's negligent of the employer not to have intervened on that. So if you take away the underlying tort as being a conditioned precedent for negligent supervision, again, the doors fly wide open. Thank you.
Thank you, Your Honor. May it please the court, appreciate the opportunity to be here. I am a graduate of Pella High School, so we've got a lot of Iowa representatives here today. I found the first arguments fascinating. It makes you realize just how difficult this climate issue has become. But I have the privilege of representing Jenna McCoy. We have some fundamental differences, Mr. Squires and I, about the posture of this case as it proceeded at the trial court level. Judge, you raised the issue of the Greenland case, and I think the Greenland case is the basis from which we pursued that, coupled with this court's recognition of negligent supervision or retention as a viable legal theory under Iowa law. We combine.
Have we ever actually said that that applies in the situation where the plaintiff is an employee?
I don't think you have, but in the Northern District in the federal court, in the Stryker case, I'm not sure how you pronounce it, it was recognized as such. That was a very comparable case.
I just was looking for a case where we have. And so do we need to recognize that here?
It seems to me that Jenna McCoy is a third party, is somebody that would come into contact with the people that this defendant hired. So I find it hard to parse out the protection that Jenna McCoy deserved from the protection that a third party not affiliated with the employer would likewise deserve.
Well, she has protections under workers' compensation that a third party would not have.
That is true. You know, one of the things that has not been mentioned is there's an exclusion in the Workers' Compensation Act for intentional actions against an employee, and I think that's another reason why the Work Comp Act never applied. She did put her employer on notice of the impact of the conduct of her supervisors.
Counsel, aren't all of your claims in negligence, negligent supervision, negligent hiring? Was there an intentional tort that they got recovery under here?
No. They got recovery under the negligent supervision and retention theory that we pled, and consistent with the court's recognition in earlier cases, that has to flow from wrongful conduct on the part of a co-employee, which we also addressed in our proof in terms of the assault and or battery on the part of Mr. Thompson or Mr. Turner. So the theory that was submitted to the jury was the negligent supervision or retention theory, but in order to get home on that, the court instructed on the issues of assault and battery. Did I answer?
You did. I was thinking about your argument on workers' compensation and how there wouldn't be coverage under that statute if it was an intentional tort, and it just struck me that the claim here wasn't that. It was a claim based on negligence.
The injury that Mr. Squires wants to focus on is the injury that flows from the conduct of Turner and or Thompson. The injury that we pursued in this case is the injury that flows from the employer's failure to do anything once she brought it to their attention. And there was a fundamental finding by the jury. They believed Jenna McCoy that she had gone to Cardella and complained. They did not believe Cardella's testimony that she did not. So the jury, I think, clearly understood the issue, that this employer had a chance to bring this to an end and did not do so.
Of care for the employer to respond to this kind of conduct in the workplace?
Well, I don't know that any cases have phrased it in terms of standard of care. I think I understand your question. What is an employer to do when they get a complaint like this? And I think
But it's a negligence claim.
the negligent supervision or retention, correct?
Yeah. Breach of duty, some sort of standard of care or standard, of conduct that would make this negligent. So what is the standard that they have to comply with in terms of response?
I think the testimony from the Cardella employees, I think their human resources person kind of laid that out. If they get a complaint like this, they had spelled out this conduct as being impermissible in their handbook. They had the responsibility to investigate the claim, and based upon the investigation of the claim, take appropriate steps to prevent the similar conduct from continuing to happen.
Flow out of their employment law obligations arising under Title VII and the Iowa Civil Rights Act?
Source. This court has also put another legal burden on them, and that is the duty to properly supervise and to not retain employees that choose to violate clear workplace standards that are set forth in their own handbook. There's another source, the Iowa Civil the Godar and the Schaaf cases, as well as the federal district court case, the Stricker case.
You lived in a world with no Iowa Civil Rights Act, no Title VII. Okay, so you wouldn't have these obligations that are imposed by law. What is the employer's duty under this kind of common law tort theory to supervise or intervene if one employee is harassing another?
Well, I think that there is a reasonableness standard based upon an investigation of the complaint and a determination as to whether that complaint has merit, and the reasonable standard to take steps to prevent it from continuing to happen. I don't know that that there's any source of standard in that situation other than reasonableness. I mean, I think anybody here would say that it was unreasonable for Jenna McCoy to have to continue to endure inappropriate touching. She testified that every time he did so, she asked him to stop. He didn't do so. He made comments to her that were sexually charged. She asked him to stop. He didn't do so. She went to the employer twice, arguably 3 times. There's a little bit of confusion in the record. She asked them to bring it to an end. They didn't do that.
It seems kind of circular, right? I mean, the reason you have Iowa Civil Rights Act, the reason you have Title VII was to do away with this kind of conduct, which was prevalent in the workplace before those statutes were implemented. So those statutes are what create the duty, what creates the expectation of reasonableness. And so then you use that standard that's wholly created by statute, and then you try to evade the statute by asserting it as a common law tort, but relying on all these duties. It seems to me this is kind of the core of the heart of preemption, is that you have this bargain where the state says, look, there are certain kinds of conduct that we're just not going to tolerate in the workplace, one of which is sexual harassment. And if that's the core of your claim, then you've got to comply with the administrative procedures in that act rather than just bootstrapping a common law assault or negligent supervision. I mean, that's kind of what I'm getting at here is what is the duty outside the Civil Rights Act?
Something quick before I respond. I thought I was correct in saying this. The Greenland case was handed down in 1993. I was thinking it was in 1993. The Civil Rights Acts have been on the books since the 60s. The Federal Civil Rights Act as well as the Iowa Civil Rights Act. So if there was no independent tort theory upon which to pursue this claim, then why do we have the Greenland case? And, you know, from my perspective as a lawyer representing somebody like Jenna McCoy, And I will concede to all the members of the court, she did not file within 300 days at the Iowa Civil Rights Commission. I don't know that it's officially in the record, but that's why we pursued this on her behalf. I'm not going to suggest otherwise to you. But as a lawyer representing, my obligation was to advise her, is there any other theory of liability you can pursue other than the Civil Rights Act? And I did the research. The Greenland case was out there. The negligent supervision and retention cases were out there. The conduct she was complaining of was pretty vivid in my mind. I told her I think there's a common law cause of action. And that's the way we pursued it. I'm sorry.
So let me follow up a little bit on Justice Waterman's questions before, because if you look at Schmidt, it speaks pretty broadly in terms of the preemption. It says, to the extent the ICRA provides a remedy for a particular discriminatory practice, its procedure is exclusive, and the claimant asserting that practice must pursue the remedy it affords. And then it goes to say that the ICRA preempts a claim when, in light of the pleadings, discrimination is made an element of the claim. And as I read your petition, it speaks about sexual harassment that would fit right into the ICRA. So I'm going back to Justice Waterman's question to your...
It's a very good question. I'm sorry, did you finish?
Hey, where are we on Schmidt versus the Greenland case that you talked about?
Of the comparison of the Schmidt case with Greenland is that Greenland recognizes a separate and distinct path forward beyond the civil rights complaint if the discrimination, if the assault and battery is not part of the discrimination. Stricker, out of the Northern District, talks about that very language, and I cited to that in the case. I think that case is still good law, and I think that's the path that we went forward. It seems to me, as I look at this, that on the one hand, you've got a statutory Civil Rights Act. On the other hand, you have a recognition by this court that there may be situations independent of the Civil Rights Act which give employees a remedy under the common law. And
help me understand your argument that the workers' compensation claim has to fail because it completely overlaps with an Iowa Civil Rights Act claim, right? Isn't that one of your arguments, that this can't be?
Argument, the basis of that argument from me is that Delgado versus Zuniga case, where there's language in that case that says if she could have filed a civil rights claim, and we concede she could have, had been brought within the 300 days, she can't file a workers' compensation claim.
In Delgado, they actually did, the plaintiff there actually did file a civil rights complaint, and so you couldn't double dip. And also, that the Court of Appeals there talked about that this isn't a Venn diagram, there's only one circle. And I think you've characterized your case as, like you just were explaining to Justice May, is that there might be something separate from when discrimination is not part. So I don't think you necessarily fall within that circle of Delgado. But before you run out of time, I want to take you back to your damages and your discussion about that the damages flowed from, not from the underlying assault and battery, but from the employer's response. The instruction number 10 very specifically says that Thompson and Turner's dangerous characteristics were a cause of damage to McCoy and requires the jury then to determine the nature and extent of the damage. Likewise, instructions 11 and 13, defining assault and defining battery, included as part of those that the act caused damage to McCoy and the amount of the damage. How can you say that the damages that were awarded here were not based on the underlying conduct, but were only based on the employer's response when those are the instructions that are given?
Negligent supervision or retention required us to prove a dangerous characteristic or wrongful conduct on the part of the employees that engaged in this conduct. We did that. I mean, you can't handcuff us and say you can't talk about what they did if you're going into negligent supervision, because that impact.
damages, where are
Flow from their failure to stop it.
evidence on that from the expert?
First to the in-house, who she thought was the human resources person.
The damages. Where's the evidence that her damage flowed not from the assault, but from the employer's response?
I don't think that you can cleanly parse out the two, but I can reasonably say to you that had they stopped this conduct, that the ongoing effect emotionally of this conduct would have been brought to an end and her damages wouldn't have occurred.
Are tied then to the underlying assault and battery?
To the extent that that's the wrongful conduct which gives rise to the negligent supervision or retention claim. You have to have it tied to some level of wrongful conduct. But
Why is that not covered by a work comp?
it's an intentional act by a co-employee which is expressly excluded under 8516 of the Work Comp Act.
I want to ask you about exactly that point. The intentional act of the co-employee is excluded, but there is no exclusion as to the employer. It's only against the employee, and your claim is against the employer, not against the employee. I'm looking at 8520 sub 1.
All I can tell you is in years past when I did a lot of comp, I had a couple of cases where the intentional act of a co-employee were raised as a complete defense too. I'd have to go back and look at the reading of the statute, and I stand corrected if it focuses solely on the employer as opposed to the conduct of the co-employee which brought about arguably a mental or physical injury. But I think that that's one of the reasons why, in my mind, this never was a workers' compensation claim.
Things. One is do you have a claim, and the other is it excluded? Is it barred, or is it barred by the statute, or is it simply outside the scope of the statute? Here it says that it's the exclusive remedy against the employer for an injury committed to the employee.
Have an injury which arose out of and in the course of the employment. And my understanding of the Work Comp Act is that if you have an intentional act causing injury by a co-employee, that by definition does not arise out of and in the course of the employment.
Your claim is negligent supervision by the employer. That's your underlying claim that you went to the jury on. How does that not arise out of the conduct of the employer as opposed to the employee?
Conduct of the employer. That arises out of the conduct of the employer, and it is recognized by an independent tort that this court has recognized, and that's the basis of us going forward with such a theory. I see that I think my time up? I'm sorry. I appreciate the opportunity and thank you.
Squires?
Thank you, Your Honors. Just to pick up briefly on the dialogue between Justice Mansfield and counsel, I think there's two different sections of the Workers' Compensation Act that are kind of at play. There is the 8520 that talks about you might have a remedy against employees for their gross negligence. The second one that plaintiff has tried to rely on appeal is 8516, which says if the incident in the workplace is an imported quarrel, in essence, that is, it originates from outside the workplace, that workers' comp is not going to cover it. That argument was never made below, so I think it's waived. Secondly, 8516 is solely an affirmative defense once a claim is made, so it's not an option for a plaintiff to rely on 8516 and say, I don't want to get into the workers' comp system.
So do you agree with 520 that if it's a negligence claim against the employer for physical harm that occurred in the workplace, that it's the exclusive remedy is workers' comp?
Your Honor. And in listening to the dialogue about the intentional conduct, the intentional tort or whatnot, I thought it worth pointing out Ms. McCoy never filed actions against the, quote, tortfeasors themselves, against Turner or Thompson. They were not included in the case. Rather, she pursued only the employer via the negligence theory. And in looking at Greenland, where the court green-lighted an assault and battery claim, I don't think that's a negligent supervision claim. It's just saying there is a possibility that there could be a tort in the workplace, and I think the workers' comp statute.
Judge Bennett and Stricker recognized, using Greenland, I think, relying on Greenland, that that at least he considered that that under Iowa law that there is a negligent supervision related to an assault by a co-employee.
Your Honor, that opinion can be read that way. Again, if we look at the timing of that opinion, 2001, it predates Harris. Secondly, the issue of workers' comp.
Cites Stricker, doesn't it?
I'd have to go back and look at it. It may. But workers' comp was not raised in Stricker, so it's somewhat apples to oranges if we look at our case. And then I did want to get onto Justice McDonald's question about the standard of care, because it's a great question when you look at this as a sexual harassment case, because as you pointed out, the statute, as well as this court's interpretation of the statute, defines what the standard of care is, including in a negligence claim, and that was the Haskenhoff case from 2017, where the court said that the standard is the employer knew or should have known of the harassment and failed to take prompt and appropriate remedial action. And the point of citing that is, again, it reminds that Ms. McCoy had a perfectly clear path to pursue her claims, and that was under the Civil Rights Act, and she could have pursued them sounding in negligence, but she didn't go that route.
So what if her complaint wouldn't rise to the level of an ICRA claim? This is hostile environment type land that we're talking about, and what if it didn't rise to the level of affecting a term of condition because she wasn't forced to quit? Maybe she didn't actually quit. It only happened a few times. So she wouldn't actually maybe have an ICRA claim. Is there room in there for having some kind of a claim outside of ICRA?
You would still need to have a theory, and the theory that we've heard would be negligent supervision. And again, that's where I say that the holding in Harris is so broad that that is not a tort we recognize in the workplace. And then you get to the parade of horribles. We would be effectively legislating against bullying in the workplace. If you have conduct that an employee doesn't like that doesn't arise to the level of discrimination or harassment, and the employer can be negligently held liable for that conduct, where does it end? Again, I think you can use the common term now, bullying, but that I think effectively is what we would be getting as a result of this case, if that's the theory it goes on.
Mr. Humphrey says. He says it's limited to a situation where you actually had an assault, which you did here, right?
Jury did find that Thompson committed an assault and battery. Yes, Your Honor.
Preemption purposes, were the assaults, the unwanted touching, grabbing the knee, et cetera, were those bound up with the sexual harassment?
May I answer the question, Your Honor? Yes. I think it's one and the same, and the district court itself categorized it, I think, as sexual battery or something to that effect, and just kind of blurred the concepts. But again, I come full circle to our motion to dismiss. This was a sexual harassment claim that was filed too late. Thank you, Your Honors.
The case of McCoy versus Cardella and Associates is hereby submitted, and court is adjourned for the morning. Thank you.